beloved creator of all that is, thank you for this beautiful day in the park. We held a grand jury and we had exactly the number of people who showed up that we needed. Some traveled from quite far, and we really appreciate the fact that they not only came, but that they arrived intact and their travel was good, and that we got the job done. Thank you for the support. Thank you for the vision. Thank you for the action we took today, and may it have good effect for the people on Oregon and for the Assembly as well. Thank you, and we appreciate all that is always given. Let it be so.
And so it is. And thank you, Charlie.
My pleasure.
My name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is an after action on what happened today, August the 1st, 2023, in downtown Portland at the grand jury meeting in the park and across the street at the Marco Hatfield building. I wrote it out as an after action report and sent it in the form of an email to the internal affairs for the U.S. Marshal Service. I got the names of three of those people, so I sent it to all three of them and sent it to 8 different FOIA accounts from the U.S. DOJ and the DOJ and the Marine Corps, and 8 of them that are responsible for FOIA. And almost 400 blind CCs. A small aside, I did that this morning and it quit, wouldn't do it. First time in years. So I redid it and it went through the second time, but it was getting balky. FOIA and claims, : I want this on the record, : one bald, large, heavily armed, tattooed deputy marshal, not a contract worker, with his second, that was a former surface Navy black shoe sailor, a man with dark hair, white skin, and prominent ears. Both refused to identify themselves at their workplace. Both refused to sign a receipt for proof of service of the document I delivered with 7 witnesses. There must always be somebody in the billet to accept service for the U.S. Marshal Service during the business day. Then he became angry when one of us identified him as a public servant. He got all upset and told us to get out of his office. And we did. I also told him to fuck off. And he did not give me orders. He said I was rude. I said he was a big, bald, tatted up deputy marshal, rude and a prick, and to fuck off. And he threatened us. And there were several women, and the adrenaline rush was disagreeable to them. They wanted to go. He had no authority to exclude 8 people. A due process violation 8 times, 18 USC 3571, 250K a pop. All 8 are members of our Article 3, Amendment 7 Civilian Court of Record. They are also all criminal investigators and federal witnesses, 18 USC 1510 and 1512. All 8 are members of our grand jury. And when we were outside of the U.S. Marshal's rented space, identified by the GSA, and we were in public space. This large, aggressive, bald, tattooed deputy with his number 2 forced exclusion upon us. I told him to fuck off again, and he said he was counting, so I gave him a bunch more. And then he misquoted and said I named him a fucker. I deny that, and Brandon witnessed it. Then he repeated. He said that we were excluded. The two of them bullied us and excluded us all, at least for today. Like a petty tyrant, he or they doubled down and excluded us from the building and from the public sidewalk and through a gate in the fence around the Marco Hatfield Federal Building. They have made 1000 Southwest 3rd a federal enclave without authority, 18 U.S.C. 3571. It seems that the First Amendment does not work at the Marco Hatfield Federal Building, 18 U.S.C. 3571. In addition, it is on Oregon and not federal land, 18 U.S.C. 3571. And there is a quiet title of foreclosure and an eviction evolved. We served those papers on them. They interfered with due process of service of 8 people. Against the U.S. Federal District Court, Courthouse number 740, the U.S. DOJ, and the Department of Homeland Security. He said I was rude. So was he. It was confrontational. He was violating the rights of 8 people. It was a confrontational situation. There was no violence. They forced us to disarm. And then they violate our unalienable rights multiple times. They were not in U.S. Marshal Service space. They had no authority in the areas of decks, ladders, passageways, elevators, and rooftop terrace. I have that in writing from the GSA. We had just concluded our 6th grand jury, the second in the park across the street. He also referred to our meeting in the park. A female had stopped and video recorded the reading of our grand jury document, but only a portion. It is available on www.orsja.org and soon to be on YouTube. We had the Courthouse 740, the DHS, and the U.S. DOJ yet to serve. Process papers on. We had only done the GSA. They were ill prepared, but their Ryan Morton got the job done. Thank you, GSA. We are now required to mail return receipt requested these documents or get 4 of us to go downtown Portland and serve the remaining 3 persons. All because of these 2 guys. Rude, obnoxious, big, intimidating. Due process for service of documents is codified. How it is to be done. The responsibilities are clear. Both parties have obligations. Ray and I've done this hundreds of times, literally. The bald, tattooed deputy marshal screwed the pooch. As one would declare in the ranks of the United States Navy, including the U.S. Marine Corps, did it big time, stand by. Due process violations are codified at $250,000 Federal Reserve notes per violation. And these two deputies racked up several against the 8 identified above. Now, the 8 identified above, the ones that they violated are members of a grand jury, a lawful grand jury on Oregon that just got through sitting in a grand jury, and they were watching as witnesses the service of their document. And these two yahoos have to get an attitude, flex their big arms and their big chests and their tattoos, and oh boy, it's going to be fun. I love the adrenaline. I sit here and don't do, never mind. I had a wonderful time. Where was I? Yeah, they're all grand jury members and they're all members of an Article 3, Amendment 7 court. They're all Oregonians. They're men and women. They're not all cap versions of some stupid game. These are de jure people. FOIA. Remember, this was a claim and FOIA. FOIA. Provide me the documents used, needed, suggested, required. I don't know what they're going to do to commence formal U.S. Code claims, including from a PAG, Private Attorney General, to file with the U.S. DOJ for RICO, that's organized crime, against the U.S. Marshal Services and the U.S. DOJ, both of the Marco Hatfield crew, including the U.S. Federal District Court of Oregon on Portland, number 740. See the examples below. There is also a claim from the Oregon Statewide Jural Assembly, aka Article 1, Section 1, the provisional government on Oregon, through its civilian court of record. Our bona fides are published at www.orsja.org. As an example, several years ago, I told Seth Urham of the U.S. DOJ, Carl Nobbs, and Mark Nordquist, both deputy marshals, that I had incontrovertible evidence that Courthouse 740 had taken $400 in filing fees twice when an Article 3, Amendment 7 court was specified on the documents, and they were not even an Article 3 court. That's fraud. I gave them the docket numbers and they did nothing. That is misprision of felony. They told me they looked and they did nothing. This was done with Raymond Senkel and Cambies Morati as witnesses. We were going down there helping the DOJ in Portland drain the swamp while Trump was supposed to be doing that in Washington. Seth Urham, U.S. DOJ deputy, heard all of this and he did nothing. This was the winter spring of 2017. This is now a formal claim of these several violations. Misprision of felony morphs into accessory after the fact, which morphs into misprision of treason, which morphs into treason. As another example, I filed 5 papers as a PAG into Bundy et al., and the judge, Anna J. Brown, had a clerk remove them from the record, and he gave 4 of them back and he kept 1. That's now a formal claim. All of this at the Marco Hatfield Federal Building on Oregon, not built on federal dirt. They never bought the dirt. Due process violation, 18 USC 3571, 250K times 5 million Oregonians. This is now a formal claim. Please read the attachments as is pertinent to the claims. P.S. This was scanned from 2 pages to 4. I did that 2 pages, And if Anna jumps in, she is exercising her First Amendment, and I yield. Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is addressed to our sheriffs. We have 36. It's your choice whether or not you want to be a sheriff, a law enforcement officer, a peace officer, a criminal investigator, an enforcer of statutes on people that are not affected by statutes, trying to treat people like persons, and adhering to the Oregon revised statutes and not to the Constitution, familiar with the ORS, but having never read the Declaration of the 13 Colonies for their independence. You glaze over when somebody starts reading constitutional law to you. You say it's too complicated. You're not stupid. You're just de facto. And you have to stop. And it's going to be just like the cop, no, the detective at the Beaverton police station back when people were wearing masks and doing all kinds of weird stuff. Charlie, Cynthia, and I were in the Beaverton police station delivering papers and claiming our unalienable rights, and they had cops in the lobby and officers in uniform. I mean, like captains and stuff, and all kinds of hoo-ha going on. And a, a detective came down, and he talked reasonable, and he was a nice guy. He even remembered me from before. And we asked him what he would do in certain cases, and they were leering at us. And he said, that's where I draw the line. So all the sheriffs have a line that they draw in their mind, depending upon their location: conservative, I-5 corridor, Democrat, tyrant. All of them have the same basic character. They chose to be that. However they got there, they chose it. You don't get to be sheriff without wanting the job. So they want to do all the sheriff stuff, some of them more than others. But as long as they're collecting a fee for a concealed carry, they have no honor. They've already broken their oath. And every sheriff on Oregon, all 36 offices of the sheriff of that county, charge a fee for a concealed carry permit. They all have no honor. One of these days, one of them is going to get to the line they can't cross. When they get to that line, they automatically become de jure. They will no longer go along with the de facto governing oligarchy out of Salem. They're not going to run that game anymore. Now, out of the 36, they're all going to eventually go from de facto to de jure with a proper oath and bond, or they're going to be gone, no longer in the system. Somebody will be in that office that will do the proper oath to a proper constitution and do the proper job. We're not going to put up with it anymore. No more infringements on our unalienable rights. So, I think a really good way is to push all of you sheriffs with 4 to 8 people or 20 and just talk to you. Who do you want to be? Do you want to be a constitutional sheriff with honor, responsibility, and do the de jure job of a sheriff, which is to first honor the constitutions, and after you do that, then worry about enforcing codes and statutes and ordinances? But first, like the doctors used to be, don't do any harm. So some of you are going to reach that point before others. And the best way is force the situation. Now that's going to be confrontational. You're not going to want 8 or 10 people telling you what to do. But that's what you're going to get because that's the way it's written. And you don't get to have law of man. You're going to have law. We're going to have order and do it properly. And I yield.
Ex parte Milligan, 71 U.S. 4 Wall 2, 1866, was a landmark decision of the U.S. Supreme Court that ruled the application of military tribunals to citizens when civilian courts are still operating as unconstitutional. In this particular case, the court was unwilling to give President Abraham Lincoln's administration the power of military commission jurisdiction, part of the administration's controversial plan to deal with Union dissenters during the American Civil War. Justice David Davis, who delivered the majority opinion, stated that martial rule can never exist when the courts are open and confined martial law to areas of military operations where war really prevails, and when it was a necessity to provide a substitute for a civil authority that had been overthrown. Chief Justice Salmon P. Chase and 3 associate justices filed a separate opinion concurring with the majority in the judgment, but asserted that Congress had the power to authorize a military commission, although it had not done so in Milligan's case. The landmark case stemmed from a trial by a military commission of Lambden P. Milligan, for whom the case is named, Stephen Horsey, William A. Bowles, and Andrew Humphreys, that convened at Indianapolis on October 21st, 1864. The charges against the men included, among others, conspiracy against the U.S. government, offering aid and comfort to the Confederates, and inciting rebellion. On December 10, 1864, Milligan, Bowles, and Horsey were found guilty on all charges and sentenced to hang. Humphreys was found guilty and sentenced to hard labor for the remainder of the war. The sentence for Humphreys was later modified, allowing his release. President Andrew Johnson commuted the sentences for Milligan, Bowles, and Horsey to life imprisonment. On May 10, 1865, Milligan's legal counsel filed a petition in the Circuit Court of the United States for the District of Indiana at Indianapolis for a writ of habeas corpus, which called for a justification of Milligan's arrest. A similar petition was filed on behalf of Bowles and Horsey. The two judges who reviewed Milligan's petition disagreed about the issue of whether the U.S. Constitution prohibited civilians from being tried by a military commission and passed the case to the U.S. Supreme Court. The case was argued before the court on March 5th and March 13th, 1866. Its decision was handed down on April 3rd, 1866. Prepared by Francis Lieber, promulgated as General Orders Number 100 by President Lincoln, 24th of April, 1863. Instructions for the Government of Armies of the United States in the Field, prepared by Francis Lieber, LLD, originally issued as General Orders Number 100, Adjutant General's Office, 1863, Washington, 1898, Government Printing Office. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. This is taken from oregonlaws.org.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.